You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury? Happy Freedom Friday. Thank you so much for tuning in. And I am so excited about today's episode as we get to sit down with one of the most experienced trial attorneys that I think I've ever had the opportunity of speaking with. And we're fortunate enough that he's going to not only explain to us as to how he got on his journey of being a trial attorney, but some of his best trial tips and tactics that have led him to an astonishing career, an award-winning career, and an experience where I think that a lot of young attorneys like myself will have an opportunity to really walk away from this interview with some hopeful trial nuggets that will allow us to have success in our futures. Joining me today is private defense attorney Al Flora. Al, please introduce yourself to the members of the jury.
It's a pleasure to meet everyone, and I look forward to this conversation, and hopefully I'll be able to pass on a number of tips to help younger lawyers. And I've been doing this for 47 years, I guess, and I'm pretty much towards the end of my career. I was the chief public defender in Luzerne County, Pennsylvania, going back about 10 years ago. And I spent almost over 30 years in the public defender's office in Luzerne County. And I started in that office when I was about 29 years of age, and I'm now 73. So, I've been there a long time. Most of the time when I first started in the public defender's office, like any young lawyer, I did a lot of misdemeanor cases. I love trying cases, so I was in trials all the time. It was something I always looked forward to, and there was times with small misdemeanor cases where I would actually be trying 2 cases a week, and because the trials were relatively short, but they were always in front of a jury. I rarely did what we call a bench trial. Early on in my career, I got into doing death penalty litigation, and I think I was practicing law about 5 years when in the public defender's office, I was part of the defense team that represented an individual by the name of George Banks, who in 1982 had killed 13 people. And it was the second largest mass murder in the country at that point in time. And that case went to trial, and we had an insanity defense. And that was one of the largest cases I handled very early on in my career. And since that period, I've tried actually, I think, 6 or 7 capital murder cases to verdict. And Banks was the only case I actually lost, and the death penalty was imposed in his case. But I handled all the appeals. I argued the case before the U.S. Supreme Court and lost there on a 5-4 vote. And Banks is still alive, actually. And he was found incompetent to be executed under Ford versus Wainwright, which basically held that in order for a person to be executed, they must have a factual as well as rational understanding of the reason why they're being executed. And he did not meet that criteria. So he was found incompetent to be executed. So much of my career has doing a criminal defense. I've represented a number of judges in criminal cases, as well as before in disciplinary proceedings. I've represented lawyers in criminal cases. So I've been around quite a while.
That was honestly one of the things that first caught my attention, was when I had an opportunity to just kind of see the trajectory of your career, was how you have been able to be in so many different positions in the system, from starting off as a misdemeanor public defender to rising all the way through the ranks to chief deputy to handling all of these big cases. I think before we get into the nitty gritty of some of your trial tips, one of the things that just popped into my head after you were telling us that, especially in our field, was how would you say, after all these years and still practicing criminal law, how would you say that you've avoided burnout? Because we hear so much about that in our space.
A lot of lawyers, especially public defenders, do experience burnout because of the high caseload volumes that they have. And even when I was chief public defender, I saw that with a lot of the lawyers that I was supervising. A lot of it is just mental stamina. You have to have the mental fortitude to handle very difficult cases. I was an individual that never got emotionally involved with my clients. My attitude was I was there to ensure that the rights of the individual were fully protected. I wasn't there to be a social worker. So my attitude in trying cases was very different, especially compared to a lot of the younger public defenders today who develop an emotional connection many times with their clients. And that can really take a toll on you. I'm not there to believe the client or disbelieve the client. I take the facts that are given to me, I look at them objectively, and then I sit down with the client and tell the client, here's what I think about your case based upon the law and the facts and the evidence that the prosecution has. And the client tells me that I want to go to trial, then I will do my utmost best to ensure that that client receives a fair trial. But my thinking is that I'm there to ensure that the constitutional rights of the individual are protected. And as a result of that, I don't get into the emotional entanglement with many defendants that I see younger lawyers get involved in. And that can really take a toll on people.
Yeah, that's definitely one of I think the harder things to balance in the career is the emotional attachments to your client and the kind of neutral mental objectiveness you have to have when dealing with this set of facts. When you started your legal career nearly 50 years ago at a public defender's office, is that where you envisioned your career starting off? Did you have prior aspirations to be a public defender?
Actually, no. When I came out of law school, my intent was to be a professional baseball umpire, not a lawyer. And my father never had an education. He was basically a saloon keeper. And when I first started out in my third year of law school, I came out of the University of Baltimore School of Law. My third year, I actually did an internship with the state's attorney's office for Baltimore County, and I was allowed to prosecute third-degree misdemeanor cases in Baltimore County, and I wanted to be a prosecutor initially. And then for a while there, I thought of going into the FBI, but they had a hiring freeze at that point in time, and so I couldn't get in. So I was very conservative early on in my life, and what happened was I was back here in Luzerne County and doing deed searches and zoning cases and divorce cases and things like that, just to try and make a buck. And one day the county commissioners saw me and they said, we're looking to hire public defenders. We need lawyers. Would you be interested? And I said, yeah, I'll give it a shot. I'll do it. What the heck? I needed the money. So I got involved and I just really liked the trial work. Then I developed a very deep commitment towards the Constitution and the rights of individual defendants.
So one of the reasons why I created this podcast was because I thought it was really valuable and important to highlight some of the work that we do, the unpopular side, the forbidden side. There's a good portion of society that think, defense attorneys are these sleazy, scummy slime bags whose only focus in life is to, get not guilties for their client, even if they didn't. And if you're a public defender, that means you couldn't hack it as a quote unquote real attorney, or you didn't get your primary job. After this lengthy career that you've had and in spaces in public defense and private, jury trials and appellate courts, what would you say to debunk that myth that public defenders aren't the real lawyers and why they're such a staple to our criminal justice system?
Public defenders handle the most difficult cases there are. And many times I've seen public defenders try and do their best under very difficult circumstances, only because of the difficulty of the case. The facts are so much against them and against the client many times. And the salaries that public defenders receive are not that great. Oftentimes they're less than what prosecutors make. And the caseloads they have to handle far exceed the national recommended standards as suggested by the American Bar Association. And so, for example, public defenders, full timers are suggested that they handle 150 felony cases a year. I've seen assistant public defenders handle 300 cases a year. And imagine trying to do that. So they're overwhelmed. And you have a system that is broken. Because they're so overwhelmed, it's difficult to give clients the attention that they need. And yet they try and do their best. And I have dealt with many assistant public defenders who are bright. Who really know how to conduct trials and appear before juries, and they give it their best shot. But I tend to think that when you look at some of these movies in which public defenders are portrayed, and I was just watching a movie the other night, and it was suggested that the public defenders, they really don't know what they're doing. They're not lawyers, things like that. I think it's unfair to the young lawyers that are out there who are dedicating their lives to representing the poor. And I think it's a very noble profession under the circumstances. But unfortunately, because of the volume of cases they're handling, burnout is very high.
I love the point about Hollywood. I talk about that a lot on this podcast, that I think that the way Hollywood portrays public defenders is honestly one of the biggest detriments to public confidence in public defenders, because I think on an individualized case, in my personal experience, the majority of individuals are actually pretty satisfied with their public defenders. There's definitely there are a handful that are not. But when portrayed in Hollywood, they're always incompetent. It was always a dissatisfied public defender. And what I wanted to do with this show is highlight that, kind of to what the point you were speaking earlier about this kind of younger generation of public defenders and where their mindset is. I think, it's fair to say that, public defenders, there's actually a wave of people seeking that job, who desire that job and that work because they know that it has so many uphill battles, and that, they don't want to strive away from that. And, obviously someone who's remained in that position as long as you have, definitely have that same type of mentality too. So, I really appreciate you again, just coming in here and sharing your knowledge to try to dispel what so many people wrongfully believe about public defenders. And as you indicated, you've had multiple serious high profile cases as a public defender and private counsel where you saw success. And so obviously, I think it's fair to say that just because someone has the title of assistant public defender, deputy public defender, they are credible, competent attorney. And, so with that, Al, I would love to start picking your brain as to what are some of the biggest takeaways from doing jury trials? What are some of the things that have become a staple of your jury trial practice that have led you to some of these great results that you were able to attain over the period of your career?
Well, I think the first thing that you have to do is establish a rapport with your client to the degree where the client is fully confident in your capabilities. And the way to do that is that you have to put yourself in a position where you communicate with your client on a regular basis, and sit down with your client and show your client that you're really interested in his side of the story, that you're interested in his welfare and the protection of his rights. Unfortunately, today, because of the very high caseloads volumes that assistant public defenders handle, it's very hard for assistant public defenders to do that. I even saw that with some of the assistants that worked under me. You're handling 300 cases. For you to sit down and have a continuous rapport with your client in light of that caseload volume, it's very difficult to do. And I can tell you that the number one complaint that judges receive about defense lawyers is that they're not communicating with their clients. And it's through no fault of the lawyer. He's just overwhelmed, and that's what leads to burnout, obviously. So I think the first thing you got to do, especially if it's really serious charges that you're dealing with, homicides, rapes, ag assaults, things of that nature, is that you have to communicate with your client on a regular basis. And that means more than just a telephone call. That means meeting with the client on a periodic basis, following up with letters, letting your client know what's going on about the case. And then when you start getting closer to trial, sitting down and spending a lot of time with the client, preparing the client for trial, explaining to the client the process, because many times you're dealing with clients that have not gone through the process before. They don't understand what their rights are, and you've got to explain all of that to them under the circumstances, and it takes time to do that. It's not something that's easy.
One of the things I want to ask you specifically as it relates to communicating with your client, because I couldn't agree more that I think client rapport is really one of the number one things an attorney should focus on if they want to see themselves having success in any case. I'm not sure how much of it comes up in East Coast cases, especially East Coast cases, but something that we deal a lot with in Southern California are interpreter cases, and just having that extra person involved in the mix. Is the use of interpreters been something that you've had to experience with your career? And in those cases, how do you try to overcome that difficulties to establish the type of rapport that you think is necessary?
It's an interesting issue. The area that I live in northeastern Pennsylvania, within the last probably 10 years, the Hispanic population has grown significantly. And yet at the same time, the Black population is relatively small in our area. Most of the capital murder cases I've done have been representing Black defendants. And I've had one involving an Hispanic from Cuba. And what we try and do with regards to the Hispanic population is we do bring interpreters in. And many times, and I found this, is that even though you have an interpreter there, and I don't speak Spanish, but I have found that you can, just by gestures, just by the tone of your voice, by how you look at the person, you can convey to that person a impression of how much you're interested in the welfare of that person without speaking in Spanish. It's a connection that you develop, and it's something that that does occur. Even though you don't speak the language, the individual that you're representing, he can sense pretty quickly whether you have the interest in his welfare, whether you have an interpreter there or not. They will sense that. And the interpreter basically is there, obviously, to pass your words along. But simply passing words along is not enough. You've got to develop an emotional connection. And by saying emotional connection, I'm talking about developing that rapport, so that person knows that you have an interest in that person's welfare. And that's what I'm talking about. You're not there to be the social worker of your client. You're not there to believe or disbelieve what your client is saying. That's not your job. You're not there as a juror. And so that connection can develop. At the same time, I can tell you that in one particular capital murder case I had a Black defendant who came out of the ghettos in New York City, and he had a very rough life growing up. And his family was very difficult to deal with. And we were dealing with them in terms of preparing for a sentencing hearing in case we reached that point. They did not trust white people. And what I had to end up doing is bringing in what we call a mitigation specialist out of Maryland who was Black. And she was in a position to communicate with the family. I was able to communicate with the defendant, no problem. And he trusted me implicitly. But the family was a different matter. And so those are the types of things you have to do. And so sometimes it may not just be dealing with the defendant. You might have to be dealing with the defendant's family. And even if it's not a capital case, you still may be dealing with the defendant's family, and you've got to be able to develop a rapport with them. And it may be that you'll have to bring an interpreter in or a social worker or something like that to help bridge that gap.
That's such an excellent point. It's one that I never even thought about, which is, again, why I love being able to have these conversations with more experienced attorneys than myself, because you're absolutely right. There's oftentimes more than just a language barrier. There could be a cultural or a religious barrier, and a good attorney will find the ways for them to still be actively involved and overcome those barriers. So I think that was an excellent point. Let me ask you another question as it relates to this first tip, as it relates to communication and rapport with your client. What have you found to be a good default practice with your clients as far as to how much you have them actively participate in developing the trial strategy and tactics?
My policy is, and this is the way I approach it, and again, a part of it is developing that rapport with the client to make sure that the client completely trusts you, is that I go over all of the evidence with the client, and I explain to the client the strengths and weaknesses of the evidence and where the prosecution may be coming from. What are the weaknesses in the prosecution's case? I go over the defendant's own statement as to what happened, and I talk to the defendant about, look, here's what I can see are the weaknesses in your statement. Here's where the prosecution will come from. And then based upon those discussions, which occur not just in one meeting, but in a period of meetings, I then discuss with the client, here's the applicable law that applies to your case. And given the particular facts, here's how this case may rise or fall. And to give them an idea. And I says, look, the likelihood of the jury acquitting you might be slim to none, or you have a 50-50 chance. So I try and give the client some kind of an idea without giving him a guarantee, obviously. And I always leave it to the client to make the ultimate decision without forcing the client, because that's one thing you can't do. So you have to watch what words you use and how you say things to the client, because you don't want it to be misinterpreted with the client turning around and saying, well, he told me to do this. He told me to go to trial. He told me to plead guilty. You want to avoid that. And the way you avoid it is by really taking the time to explain all the pros and cons of the case, and then saying to the client, all right, do you understand everything? Yes, I do. What would you like to do under these circumstances? And whatever the client says, you say, fine. I'm not going to ask you again. This is the position you want to take. This is what I'm going to go with, and that's it.
When you find yourself in an active trial, do you find yourself potentially conferring or talking to a client about what evidence or which picture specifically you want to highlight? Or, one of the things I tend to do with my clients, especially from the start, so I think that they're actively involved throughout, is really try to get their input in jury selection. I mean, ultimately, my gut feeling and what I want to do is the leading decision making, but I always want to make sure that they're happy with that selection too. So I like to involve them in that process. Where do you stand on that?
The way I do it is I do explain to the client up front that matters of strategy are within my control. That's not to say that I don't discuss strategy with the client. When we start off with the jury selection process, I don't go and discuss with the client in advance what questions I'm going to ask the prospective jurors. When I get done with my questioning before I release the juror, I will say to the client, is there anything else you would like me to ask? Do you have any concerns? The client will tell me, and then I will make the decision whether further inquiry should be made. And I take that approach also with witnesses during the trial itself. I will cross-examine a witness, or I'll conduct a direct examination of the witness. And before I release that witness, I'll say to the client, is there anything else you would like me to ask? Is there anything you feel that's important? The client will tell me, and then I will make the decision at that point as to what to do. Many times I will not follow through as to what the client wants me to do, but that's But the client doesn't know or understand, and doesn't understand where you may be going on some things. So the client may think that the question's appropriate, where actually an answer could really hurt the client. And I've done that not only with indigent defendants, but I've done that with judges that I've represented in federal court as well as state courts, and that have been charged with very serious crimes, where the judge who is the defendant will be saying to me, "Al, ask the witness this question or that question," and I have to say to this judge, "No, I'm not going to ask that question because it will hurt you." And so that's your obligation. You have to do that.
Yeah, their understanding of rules of evidence is also have created quite a few funny conversations for me, because they're the source of the basis of the question, and and it's like, that's hearsay. It puts you directly in line with everything, so it's really a mess. And I think that's a good approach, and because I think, as you said, one of the things I think juries pick up throughout trial is obviously what the attorneys are saying, but body language. If a jury sees you and your client having nonverbal detachment as far as what's going on, I think that there's something for them to pick up on. So I really like that, your first focus was developing on client rapport and communication, because from start to finish, there's so many different impacts that having good or bad client rapport will have on a case. So I thought that was excellent. Was there anything else you wanted to touch on for that last tip?
No, I think that's pretty well lit on that first tip.
Okay, how about a second one? I think maybe 3 or 4 of your best ones, I think, will be enough of a appetite for our audience off one episode. Maybe if we get enough traction, we'll bring you back and keep picking this master brain of yours. But how about a second tip?
Second tip is know the facts of your case. Have a complete command of those facts. Many times I see young lawyers in jury trials, they're standing there and they're trying to flip through notes, trying to remember what the facts are. They're flipping through police reports. They're there stumbling, things like that. You can't do that. To be an effective trial lawyer, you have to be pretty free-flowing. And to do that, you have to have a command of your facts, whether you're questioning witnesses, or you're doing an opening argument or a closing argument in front of a jury, or whether you're making an oral argument to a judge on an evidentiary issue. It's important to know the facts of the case. And one of the main reasons why you need to know the facts of the case, especially in advance, is not only to prepare for cross-examination of prosecution witnesses, but also to determine what facts the prosecution is going to seek to introduce into evidence, which you may be obligated to object to prior to trial on evidentiary grounds through the filing of a motion in limine. And that is very important. If you don't have a command of the facts, then you will not know the evidentiary issues that are going to arise in the case, and you're going to get caught flat-footed during the course of a trial. And as a result, you may not be making objections, which you're obligated to make. The errors will be waived, and you'll be looking at an ineffective assistance of counsel claim.
I really like that I'm my own personal kind of tips are falling right in line with yours. That lets me to know that I'm somewhat on the right path and doing the right thing, because it is my mantra that when I go into any kind of jury trial, that I know the facts better than anyone in the courtroom. The officers, the prosecutor, and the client himself, because I've been able to firsthand dissect every piece of evidence that I have and that I get that's going to be present. Let me ask you this, especially as you get into the more difficult cases, the capital murders, the media cases, when you start dealing with cases that have very voluminous pages of evidence, what's your tip or strategy to sort all that stuff, to dissect some of the filler versus the real important stuff?
Well, number one, even if it's filler, you have to review it. There's no two ways about that. And it's a matter of putting your trial notebook together. And what I do is on police reports or other material that I think is significant, I'll go through and I'll highlight certain things that I think are really important. I have a very good memory, so it's easy for me to read something and then remember what I've read for a long period of time. So if I get up in front of a jury or I'm questioning, a lot of times I don't even need a note. I just remember what I've read. And then if I'm trying to cross-examine a witness and the witness denies saying certain things, I have in my notebook the spot where that information is coming from, and I have very easy access to it, and I can just pull it right out and show it to the witness. So I think the more you read your material, the more comfortable you become with it, and the more you remember what you've read. So just preparing for a trial and reading a police report once and getting ready for the trial, that's not going to cut it. I can tell you that on major cases, I will sometimes read the same report maybe 10 times. So, it takes a lot. I mean, it's misdemeanor cases is a different thing. You might be dealing with just one police report, and that's pretty easy. But when you get into the complex cases, you've got to read those reports multiple times to get a really good handle on things. And that's the way I do it. I've seen some lawyers, experienced lawyers, they will have notes. They will be using notepads and they'll use checkoff lists and things like that. And that's fine. It doesn't work for me, but that's fine. So you got to find something that you're comfortable with. And yet at the same time, you won't be married to it in the courtroom, because courtrooms have to be, in many ways, from a defense standpoint, free flowing. And if you start getting too rigid, if you start relying upon that piece of paper in front of you, you're going to miss the broader picture, and the jury's going to look at you and say, this guy really doesn't have a command of what's going on here.
Throughout your career, what kind of difficulty would you say you've experienced with the advancement in technology and how now you're incorporating those into cases? Because, that's to this point, knowing the facts, it's, because they'll say one thing in the police report, but obviously sometimes every now and again, that's not what pans out on the body-worn camera. And, in talking to some of my elder attorneys in my office, even the whole process of discovery has changed from obviously everything being paper to now everything being digital. Has that advancement in technology really played a role into ultimately how you prepare your cases and what kind of materials you take into a trial?
Yes, in a couple of different ways. I'm probably going back to maybe around 2002, 2003. I started using PowerPoints in my presentations in capital murder cases. That also involves the showing juries pieces of evidence, things of that nature, up on a large screen, and that has become a staple today in doing defense work, especially in major cases. Now, one of the things that I have found is that depending upon the case, I don't think when you're doing a closing argument in a major case that a PowerPoint is as effective as it is using a large chart on an easel in front of the jury, where you have certain things written on the chart as an outline. And then you go off of that, compared to throwing an outline up on a large screen further away. And it has to do more with intimacy. You're there closer to the jury, the chart's right there, they're looking right at that chart, whereas they're not staring away from you out into oblivion looking at some screen. So I've found that more effective in closing arguments, as well as opening arguments. Many times I'll use a chart instead of a screen. But in terms of presenting evidence during the trial, we use, a projector, and I think that's very effective, especially when you start getting into pictures, when you start getting into crime scenes, things of that nature. That gives you a really good presentation rather than passing pictures out to the jury during the course of the case. The other thing that I found, especially with body cams, and I can tell you this, some years ago I was representing a lawyer. He was pulled over for a DUI, and he had a small child in the car. And if he was convicted, he would have been looking at a mandatory minimum of 3 years in Pennsylvania in a state prison. And the police were coming one way, he was going the other way. And the basis for the stop is that he crossed the center line of the highway. The police had a camera in the car, and we were able to get that. And as a result of that camera, we were able to show that my client never crossed the center line, and therefore there was no basis for the stop, and the charges were ultimately thrown out. So the fact that the police now have body cams, they have cameras in the car, that is something that defense lawyers have to get their hands on almost immediately, because a lot of that material is exculpatory in nature.
I couldn't agree more. And that goes back to, even though you might consider it filler, you have to go through it, because there have been definitely a handful of cases where in the fading seconds of a body worn camera, you see something, you hear something, and it really just can turn a case on its head. So I absolutely love that second tip, and it fits right in par with how you can be successful in a case. Develop that client rapport, know the facts better than anyone else. How about a third tip?
Third tip basically would be dealing with cross-examination of prosecution witnesses. Cross-examination is something that it's not easy to learn. And the mistake that I find a lot of young lawyers make is that they start cross-examining a witness without knowing where they're going. It's not just trying to show inconsistencies in a witness's statement. You have to have an objective. What's the point you're going to try and make? And sometimes the point that you're making is really through the question itself, and not so much as the answer that's given. For example, you might say to a prosecution witness, wouldn't you agree that at 75 feet away at night, that you were unable to identify this particular defendant? And the person's going to say, oh, I could still identify him. But what you're doing is, by the very nature of the question, you're putting that into the juror's mind. You're creating doubt. And so you have to know where you're going. Simply to ask questions for the sake of asking questions and to try and catch a witness on some minor, insignificant point, all you're doing is wasting time, and you're getting the jury upset. And they're looking at you saying, why are you bothering here? The other thing you have to do in cross-examining witnesses, you have to know when to back off, when to change your approach and come from a different angle. And because sometimes witnesses will pick up as to where you're going, and they'll be able to anticipate your questions. So you have to know, how do I get around this? Sometimes you may be faced with a situation where you want to bring out the witness's demeanor, his true demeanor or her true demeanor. And because you're trying to get across to the juror that this prosecution witness really isn't what he or she makes himself out to be. To give you an example, let's say you have a prosecution witness who says he or she was extorted by a judge and had to pay money to this judge as a result of the extortion. What you want to do is you want to question the witness in such a way to show that this witness, being a lawyer himself, couldn't be extorted. And you do that by trying to bring out of this lawyer witness his demeanor, to show that he is aggressive in nature, that he will stand up to defense lawyers in cross-examination. And it almost looks like you're being beaten down as the defense lawyer, when what you really are trying to do is get across to the jury as to how this guy thinks, and that he's not someone that's going to be easily intimidated or extorted by anybody. And that's an example.
I absolutely love cross-examination. So, and it is a defense attorney's bread and butter. So it makes absolute sense that that would be one of your tips to have success in the courtroom, is to master that skill. I absolutely love love cross-examination. I'm going to take a moment to say that if there's any attorney out there listening, young or old, and you want to brainstorm a cross-examination, please reach out to me. You can contact me at lhursty@membersofthejurypod.com. Find me on social media at Members of the Jury or MOTJ Pod. DM me. I'm happy to do that. I was able to, again, the power of social media, that's how I was able to find Al and connect. So I would please encourage anyone who has that desire to do that. Or if you yourself want to be a guest or know someone that would, please send them my way. I'm always looking to talk to aspiring and experienced public defenders. One of the comments and feedbacks that I often get sometimes in my cross-examination, Al, is that on cross-examination, you can capture more bees with honey than vinegar. As I tend to have a little bit of vinegar spice to my cross-examination. Do you happen to have a stance on that philosophy?
Every witness is different. And I don't subscribe to a particular philosophy. What I do is I look at the nature of the case, and I look at each prospective witness individually and then make a decision beforehand how I'm going to approach this witness. And that decision, however, I may modify it during the course of a cross-examination. I may then take a different approach depending on how things are going. And so you have to maintain that level of flexibility. Obviously, dealing, for example, if you're cross-examining a 6 or 7-year-old in a sexual abuse case involving a child, that's going to be a lot different than cross-examining a woman who's in her 30s who has accused your client of rape. So it's very different. And you have to know how to approach children, how to question children, the types of questions you can ask so they can understand the questions. And children are very difficult to deal with to begin with on the witness stand. And so it really depends on the demeanor of the witness, the intelligence level of the witness. So I don't think there's any one rule that can be applied under any circumstance.
Off the top of your head, can you think of any resources or materials that an attorney who wanted to get better at cross-examination should turn to?
Best thing the attorney can do is sit in courtrooms and watch more experienced attorneys and to watch how they cross-examine witnesses, especially in major cases. For example, most of us heard about the Murdoch case down in, I think, South Carolina or whatever it was. And I watched a little bit of it. And I thought the defense lawyers, though they had an extremely difficult case, I thought they did a very effective job on cross-examination. And you could tell they had command of their facts and everything. And so that's how you get better. That's how I learned. I would go in and sit in on cases and watch lawyers. And I would watch trial judges to see how they conduct trials. And that's what you have to do if you want to get good.
That's fantastic advice. And honestly, when I first interned at the public defender's office, it was that ability to pop into almost any courtroom and see one of my colleagues performing some type of motion or some type of trial. Because as we all know, statistically, 90% of cases don't go to trial. But because public defenders handle over 80% of all cases who go through the criminal justice system, a lot of those 10% of cases that do go to trial fall within the public defender's office. And so I absolutely love that advice. One of the last things before we wrap up the show that I wanted to get your advice on, and it falls directly into what you were just talking about, because I noticed that throughout your career, you've had the ability to handle some high profile cases. And currently, as in my 6 year of practice, and I'm on homicide watch, and I don't necessarily anticipate getting any kind of high profile or media case anytime soon. But one of the things I was wondering about is, from an experienced lawyer like yourself, is how do you not get lost in the moment of those situations? I know that a lot of things are status quo as far as the cases, but does the added element of something being a media or a high profile case change anything about the process?
Well, anytime you're involved in a high profile case, especially a case that attracts national attention or international attention for that matter, dealing with the media can be very, very difficult. And you have to really stay focused on what's in the best interest of your client. And many times, the best interest is that you don't say anything to the media. While at the same time, you're sitting there saying to yourself that what's being reported in the media is going to influence a jury pool. And as a result of that, when you get into voir dire prospective jurors, you're going to be asking a whole series of questions dealing with publicity and to the degree to which publicity has influenced prospective jurors and their opinions and things of that nature. And so it can be very, very difficult. At the same time, you can have situations where your client will want you to make comments to the media because they don't like what the media is saying about the client. That can be very dangerous. And you have to be really careful with that. From a defense perspective, there are ethical rules that will apply to defense lawyers in what they say to the media. One of the things is if there's a mistake the media makes, you obviously have an obligation and you can correct that mistake. But you can't go out there and just start expressing your opinion about the guilt or innocence of your client. That doesn't work that way. And those cases are very difficult. And you try and stay out of the limelight as best you can. When you're in the courtroom, you know the media is there. You know that the artists are there drawing your picture and all that kind of crazy stuff. But if you have the mental fortitude, you can pretty much block all of that out and just focus on your individual case. And but then at the same time, you've got to watch as you're trying the case. You've got to be looking at the papers. You've got to be looking at the TV to see what's being reported, because that could impact your jury. And you might be coming in the very next day and saying to the judge, we want you to voir dire the jury to see if they've heard or read anything during this trial. So that's your obligation too. If you've got a situation where you've moved for a change of venue or veneer prior to trial and that's been denied, you may be going during the course of jury selection, and you may be renewing that motion based upon additional media reports that have come to light. And so media coverage creates a lot of problems.
I totally understand that. And I think that you made an excellent point of having the mental fortitude of sticking through it. And going back to our other point, to knowing all the facts, I could see how that is an additional wrinkle, because you are going to have to go through a whole day of trial and evidence to then get home and potentially review what things are being said in the media to see if they have a significant prejudicial effect, because that does play a role. So I think those have been 3 amazing tips, Al. I really appreciate you spending the time and breaking those down for us. The last question I always ask my guests, and especially an individual who's been in the space for nearly 5 decades and has seen over 200 verdicts, I think you absolutely know the value of a case and the importance of the jury process we have in society. So let me ask you this. What is the significance of taking matters to the box?
It's the most important part of our criminal justice system. Or at that point in time, the defendant is judged by a jury of his peers. And by his peers, we're not talking about people that come from the same walks of life. We talk about citizens that come from a variety of walks of life and bring together different views and different ideas and hold true to a constitutional principle that every defendant is presumed innocent under the law. And the prosecution has the burden of proof. And the jurors separate injustice from justice. The jurors protect the average person from unwarranted prosecutions, from prosecutions that are based not on evidence, but on suspicion. And without a jury, we would not have the system of justice we have today.
Amen, Al. Amen. I know that there's definitely changes and reform that will continuously need to be implemented into our criminal justice system. But at the end of the day, I'm very happy that at its core, we have that fundamental right to a jury trial. And I love to see when people exercise that, have their day in court, and get success. I think that you've given us 3 tips to help any attorney who's listening a pathway to success when they go into a jury trial. So I just wanted to thank you again so much for your time, for your knowledge, and for your experience.
Well, I thank you for inviting me on your podcast and wish you the best in your career. And I hope I've helped at least one young lawyer out there.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.